Please rise. The Justice of the Appellate Division, Supreme Court, First Department. He, all persons having business with the appellate will draw near. Give your attendance, shall be heard.
All right, good afternoon. Oh, not that crowded. I got 5.5 hours and there's nobody here. Okay, all right. We have 5.5 hours of argument time requested. The size of the audience is deceptive, I guess. You know the speech I'll make. The clock is for you, the clock's not for us. We know and we've read your briefs and pretty familiar with the record. So having said that, first case up, People versus Bruce Cole. 5 and 2. 5 and 2 and 5. Thank you. Mosinski versus Quadrum 38. 5 and 2.
Respondents, 5 and 2.
You only get one time. 5. Oh no, you could ask. You could ask. You just don't ask, don't know. B Diamond. It's submitted. Dos Mascolo versus Board of Managers. 5 and 2. 5, 2 and 5. Thank you. Greater New York, there's two cases, 5 and 6. Greater New York Mutual versus Canali Insurance. 5 and 2. Oh, hang on a second. 5 and 2, I'm sorry? 5, thank you. I mean, those are two identical issues, right?
They're identical.
Right. Perfect, thank you. I like this group. They actually listened to what I said. Perfect. People versus Randy Paulino.
Mr. Paulino,
3 and 1. 2 minutes, okay. 3 and 1 and 2, thank you. 45 Stren LLC versus Strongen. 6 and 3. 4 minutes. 6, 3 and 4, thank you. Ford Campus Realty, that's submitted. Number 10, Nunes versus SY Project, it's submitted. Oh. Well, who are you? No one's here, you want to submit?
They have 2 minutes,
Okay. 11, number 11, FPG Maiden versus Bank Leumi. Oh, did I not make?
I have 2 minutes, I'll do a minute.
No. Let's rewind. Hold on a second. FPG, have a seat. Let's go back to Nunes versus SY Project Prospect. Who's counsel? Are you on Nunes versus SY Prospect? Okay. So the appellant?
Appellant 5 and 2, Your Honor.
5 and 2. Respondent? 4 minutes. Okay. 5, 2 and 4. Thank you. Now FPG Maiden versus Bank Leumi.
Appellants 7 and 3, Your Honor. Respondent 7.
Okay. 7 and 3 and 7. Thank you. Number 12, CO versus City of New York. I'm sorry. 5 and 2. 5, great, thank you. 5 and 2 and 5. Number 13, People versus Andrew Lassane. That's submitted. And last case, Anonymous versus Anonymous is submitted. Thank you. First case up, People versus Cole. Okay, counsel, thank you.
Good afternoon, Your Honors. Before trial, co-defendant's counsel announced that he would pummel my client mercilessly, and that's precisely what happened at trial. At every chance, he reinforced that Mr. Cole and the other men threatened the complainant, thereby conceding the attempted robbery, and but for his client, something really regrettable would have happened. That is irreconcilable with my client's defense. My client's defense was that this was an accident, or at most a bottle scheme. Mr. Williams' defense was that he convinced the other men, including my client, who had been threatening and aggressive, threatening is all that's needed to make out attempted robbery, not to resort to actual violence. Conceding that my client had threatened the complainant, that's the whole ballgame, Your Honors. Not only is that irreconcilable with my client's defense.
How did you make the case for a severance to the trial judge? What is it that you said?
So first, the motion was made in
Williams.
by Williams, which my client joined, and my client also made the motion via the omnibus. Citing Maboubian, they said that the defenses would be irreconcilable. Mr. Williams said, I'm going to pummel him mercilessly. And most importantly, Your Honor, this is a merits question. The question before the motion court was what the defenses would show. This court is not bound by that
Would you go
posture.
back specifically to what you alleged? Because as I understood it, your motion in the omnibus motion was pretty vague, and then you sort of said that you would supplement it and didn't at that point. And then when you later joined the other motion, I didn't think you made an independent showing. Did you?
There was no independent showing made, but crucially, Your Honor, you are not bound by that showing. Maboubian makes crystal clear, and the people concede that Your Honors, for purposes of showing irreconcilability, look at the trial as a whole. That is crystal clear from Maboubian. The site is 74 New York 2nd at 184 to 185, Accord Figueroa. And Your Honor, I think Figueroa is really directly on point.
Did you also reserve to make a further submission after counsel viewed the videos and never?
Well, but instead of doing that, Your Honor, he just simply joined Mr. Williams' motion, and this court is, I mean, there's case after case saying that joining.
I know it's preserved.
It's
that
preserved.
You can do it. I'm not questioning. Just want to know, what was told to the trial judge. What information he had in front of him.
I can't stress enough, Your Honor, that the question of what information was before the trial, the motion judge, is not the question for this panel. The question for this panel, because this is preserved, is what happened at trial. That said, there's no question that the motion court had enough information before it to make out the two defenses. And the best evidence of that, Your Honor, is that the people in opposing the motion had absolutely no problem in guessing what the defense would be. To quote, as forecast by Mr. Cole's statement, which was before the motion court because of the Huntley hearing, he will argue that he did not intend to rob the complaining witness and that what occurred before them was the accident. That was the trial defense. I, again, would urge this court to look at Figueroa. It's really on all fours. Just like there, the defendant's statement came before the motion court via the Huntley hearing. This panel said, this court said, that's enough to preserve the issue. The substance of the defenses were before the motion court because they came in via the statements at the Huntley. And most importantly, under Maboubian, we, the appellate division, are not bound by the record before the motion court. We look at the trial as a whole. I'm sorry, Your Honor.
I apologize, I didn't have a chance to read the Williams record, but this court affirmed Williams' conviction on this case.
On this case, not making this argument.
No, that was the question I was asking. In other words,
No.
even though he joined in the motion here, Williams joined in this, or rather they joined, strike that. Cole joined in, somebody joined Williams' motion to sever.
My client joined Williams' motion.
Joined Williams' motion, but that issue didn't go up in that appeal.
Exactly, Your Honor.
So, counsel, the statements that they're going to pummel your client and was going to act as a second prosecutor, those obviously are not good statements. But what actually happened at trial? What did Williams add that was not already elicited by the victim?
I think the only contested issue here, Your Honor, is whether what happened on the street amounted to threats of
Force.
Threats of imminent force. On that, the only evidence was the complainant's story, and he had some reliability problems. When you have the co-defendant conceding at every opportunity, yeah, this was an attempted robbery.
But specifically, what did the co-defendant concede? Because the way that I understood it, he conceded what your client conceded, right? That he was there, that something happened that may have been a bottle scam. And then the difference was, in other words, why couldn't the jury believe both Williams's position that he had nothing to do with it and your client's position that I was there involved, but there was no force?
The key question is what it is. Mr. Williams' counsel says over and over, these were threats, these men were aggressive. Threats, that's the ball game, Your Honor. And I think there's a real difference between the prosecution trying to prove its case beyond a reasonable doubt and co-defendants saying, you know what, they did it. That's the risk of a conviction based on that alone is enormous.
Okay, thank you.
Thank you, Your Honor.
May it please the court, Alex King for the people. As Your Honor's
Counsel,
questions.
when you have a co-defendant's attorney saying, I'm going to be the second prosecutor here, why not sever?
If that were the test, Your Honor, any co-defendant could say that, and that would be the whole ballgame, as my friend suggests.
Did that actually happen? Did he bring that threat to fruition?
He did not. So Your Honor is referring to step 2 of the Mabubian analysis. And the allegedly objectionable testimony that Williams' counsel elicited merely tracked what defense counsel had admitted, which is that this defendant acted aggressively. At Mabubian step 1.
Acting aggressively does not necessarily mean acting forcefully, right?
Exactly. That's exactly correct, Your Honor.
I mean, so the jury was freed. I mean, it didn't have to reject. They could have believed Williams saying, I didn't do anything. I just happened to be there at the wrong time, and also believe defendant's argument or defense saying, I was aggressive, but I didn't do anything forceful or intimidating or anything like that. So those two kind of arguments don't really contradict each other.
Yes, Your Honor is exactly correct. At Mabubian step 1, defendant.
There was nothing, I'm sorry, there was nothing at trial where Williams says, he did everything. My co-defendant is the one that did the threatening, did the aggressive, did the force. I don't think that came out at trial.
You're correct, Your Honor. So that is Mabubian step 1. We just spoke about Mabubian step 2.
Is it fair to say that there's a view of this that Williams says, I was there to help, and Cole says, I didn't do anything wrong?
So Cole ultimately
Which
acknowledged.
is not necessarily in conflict.
Cole's ultimate defense was not in conflict with what Williams said. Williams
And
said,
it wasn't criminal. Well, the defendant's ultimate claim is, well, this may not have been a nice thing to do, but it wasn't criminal.
That's exactly correct. That was the core of his defense. Mabubian aside, even if there was an error here, it would have been harmless given the overwhelming strength of the people's proof. In response to that proof, defendant effectively asked the jury to believe that the following conduct did not amount to threatening force, namely surrounding a stranger in the dead of night and aggressively asking, defendant's term, asking for his money while pushing him, shoving him, swearing at him, and yelling at him for about an hour. That defense was completely implausible in light of the people's evidence, and that is why the jury convicted defendant. We ask that you affirm.
Thank you.
Justice Soing, I could not disagree more that the two defenses could both be credited. There is a world in which Mr. Williams could have presented a defense saying it wasn't me, I don't know what was happening. That wasn't Mr. Williams' defense.
What is exactly that happened at trial then? Point to something in the record for me.
From opening where Mr. Williams' counsel says these were threats, through the cross-examination of every prosecution witness, where he says, my client didn't threaten them, they did, right? Yes, that's correct. Threats versus non-threats, through the conclusion where again he says these were threats. And then perhaps most prejudicially, I cannot imagine the prosecution would have gotten away with this. The defense that but for Mr. Williams intervening, something really bad would have happened is just extraordinarily prejudicial.
And how did they put that evidence of that in?
It was made via argument, Your Honor, and of course the jury heard that. My point is the effect on the jury, Your Honor. To have the co-defendant concede at every point, yes, there was threatening behavior there, just sever the two trials. That's how you get rid of this
Were there
risk
any
of
objections
prejudice.
to those kind of opening statements?
I'm sorry, Your
Were there
Honor.
objections to those opening statements?
There was well, you don't have to renew the motion to sever, Your Honor.
Okay. Okay,
Right? Okay, thank you very
okay,
much.
thank you. Next case, Mosinski versus Quadrum. Okay. All set, thanks.
Good afternoon. Nicholas Paslow for Appellate Defendants. The lower court's decision on the summary judgment in favor of plaintiff was incorrect for two reasons. It improperly found as a matter of law that the fire extinguisher stand that had held the fire extinguisher was defective. The defendants properly rebutted. The opinion...
How did you, I'm sorry, how did you properly rebut in this case or on this record where as a matter of law, a spoliation sanction was made against you? You didn't have any right to proffer any kind of defense or have any of your counter record to suggest that their prima facie case wasn't made.
Yes, respectfully, that is not the, I was precluded from offering evidence as the condition of the fire extinguisher. The expert that was submitted on behalf of plaintiff's employer, which plaintiff relied on, came to various conclusions regarding the conditions. We applied, our expert used those same conclusions as far as the height, the bracket, the nail. The issue that we rebutted was the applicability of certain codes and sections. Specifically, the expert that was relied on by plaintiff and the court said that Industrial Code Section 23-1.11 applied to the fire extinguisher stand. The court actually said that's not true and dismissed the 241-6 claim, but still found that there was a defect in the stand. It didn't specify the stand, but we rebutted other code sections such as the fire study guide that said that it was required to be a 4x4 and it was a 2x4. There's no dispute whether it was a 2x4 or a 4x4. There's no requirement that it be a 4x4. There's no applicable law. We did not offer new evidence as the condition of the fire extinguisher stand. We're merely providing an alternative opinion regarding the applicability of these codes. And the lower court improperly found that these code sections apply and were violated, but that is simply not true. This code section, there's no code section saying it has to be a 4x4. There's no code section saying there had to be 2 nails or screws. These are non-existent code sections that were improperly relied on. And we rebutted that with proper expert testimony. And again, and the second point is the
You rebutted it with expert testimony, but the court said that your expert affidavit was insufficient to raise an issue of fact in light of the preclusion order, correct?
Correct. We argue that that's not the proper conclusion because the expert can't simply make up a code section that's applicable.
But Crawford did not, he pointed to a specific provision at page 958 of the record. He says the design deviated from the specifications in the S-56 FDNY document and included the use of a 2x4 rather than a 4x4. The lumber was leaning and not vertical and the bucket was only half filled with concrete. So he does point to a specific standard.
Yeah, yes, that's the study guide I referred to. I mean, this is a matter of expert opinion that should be, a jury should be allowed to assess the credibility of 2 experts. One expert looks at the study guide and said, the study guide has a photo of a 4x4 in it. There's no requirement saying you should use a 4x4. It says we're providing various examples of what a fire extinguisher stand could be. Our expert says it's one of many examples. There's no wording in that reference statute saying this needs to be a 4x4. It says it can't be more than 5 feet. It has to be more than 6 inches off the ground. It does not say it has to be a 4x4. Our expert did not provide. We don't deny that it was a 4x4 or a 2x4. That's not in dispute. The dispute is the opinion of the expert and whether a 4x4 is required. And that is, we're not precluded from offering.
I'm still stuck on why you should be able to produce the expert to testify to that, given the preclusion order.
we're precluded from offering evidence, new conflicting. We can't just say if they came in and said the bracket was improper and it should have had an extra prong or something like that, or that it was damaged after the accident. We can't come and say it wasn't damaged because we don't have the stand, but we're still allowed to dispute the validity of what code sections apply. And the lower court themselves rejected the applicability of the Industrial Code Section 23-1.11. They said this is not applicable to a fire extinguisher stand, and that was based on case law, but also the opinion of our expert.
Okay, thank you.
Good afternoon, Your Honors, and if it may please the court.
What did Dr. Levitan say about the use of a 2x4 rather than a 4x4?
Excuse me, may you repeat that, Your Honor?
What did Dr. Levitan say about the use of the 2x4 lumber rather than a 4x4? Or was nothing said about it?
Respectfully, Your Honor.
Crawford, on page 958, says you have to use a 4x4 rather than a 2x4.
Yes, Your Honor.
So the appellant's lawyer is saying, well, that this was contradicted by Dr. Levitan. Was it?
Our position is that regardless of whether it was contradicted, it's the simple fact that the lower court was correct in finding for spoliation as against the appellants. The instrumentality of the
What
act.
specifically was spoliated?
The fire extinguisher and the fire extinguisher stand that were directly involved in the accident regarding the plaintiff, Paul Mosinski.
But there are pictures of it.
Yes, there are pictures of it,
From
Your
the
Honor.
pictures, they know the size of the lumber, right?
The pictures do portray lumber to some extent, yes, without question.
And you know that it's a 2x4 rather than a 4x4 from the lumber.
I would not, as a layperson, know.
But the experts say that they know from looking at it, right?
One expert says one thing and another expert says another. You're absolutely correct, Your Honor. Respectfully, it is our position that the appellants are properly precluded from offering any evidence at the time of trial, and including...
That would include expert testimony or evidence as well, right?
Yes, with regard
Evidence
to...
is evidence.
Well, with regard to dispositive motion practice as well. The point and purpose of dispositive motion practice is to narrow facts in order to determine issues that do not need to go to trial simply because there's no issue of fact in order to be brought before a jury.
But there is a picture. So you put in evidence relating that's derived from using the picture, right?
Yes, Your Honor.
So is the defendant allowed to put in evidence by using the picture?
Respectfully, they are not. They have been precluded from offering evidence as to the fire extinguisher and the fire extinguisher stand. There is no possible way that they could opine and create and offer differing evidence with regard to the fire extinguisher stand without opining on the instrumentality of the accident.
That doesn't mean that they're precluded from offering evidence, but they're not precluded from poking holes in your expert's testimony. And I didn't see that in the record where they're trying to undermine your expert somehow by saying, oh, this expert looked at the wrong photo, this expert did this, that. You know what I'm saying?
Well, I understand what you're saying, Your Honor, but by allowing this type of argument, you're basically creating a two-tiered level of admissibility, whereby for dispositive motion practice, as to a spoliation charge, one may submit expert evidence that will never be seen at the time of trial. So,
No, I'm not.
I apologize.
I'm not disagreeing with you. What I'm saying is, in terms of what the defendant could do in the face of a preclusion order, is he's dealt the cards that he has to play the hand that he's dealt, right? So in this case here, he only has the only person that we have here for purposes of this case is your expert, right? So that there's nothing that precludes him in a motion for summary judgment to say that your expert is not qualified, right? You could say that, he could argue that, right? There's no reason, like, he's not precluded from doing that, right? Because if your expert was some sort of aquatic person rather than an engineer, that would be an argument to be made, right? I'm just
Oh, no,
pointing
I
out.
understand what you're saying, Your Honor,
Right,
and,
okay.
and the qualifications of
And
the
that's
expert.
not what was done here.
No, well, the qualifications of the expert never brought up. But I do believe that what was done here is the fact that there was a separate expert report that was put in, and there's no other way in order to make the determinations that were made by the expert report without opining on the fire extinguisher and the fire extinguisher stand, even regarding the photographs that Your Honor did bring up that do exist.
So on this record, if I understand it correctly, by granting your client summary judgment on a 200 claim, which is a negligent claim,
Yes.
you simply are going forward to a jury trial on an inquest on damages. It's really on damages, right?
Yes. Essentially, any comparative negligence would be determined at the time of trial.
That's a separate
pursuant
issue.
to-
That's a damages question.
Yes. We would move forward as the damage. I'm sorry, Your Honor. Yes?
It's your position that under this spoliation order, your expert could opine on the photo, but basically the defendant's expert can't.
Absolutely, Your Honor. The point and purpose of the spoliation is the simple fact that the defendants were aware and were put on notice that litigation may occur. They removed the fire extinguisher and fire extinguisher stand from the construction site. They placed it in a shanty, and then it disappeared. There's no question as to that. This was never brought up. The appeal was never perfected. Accordingly, the point and purpose of spoliation is specifically to ostensibly punish the side for spoliating evidence, and we believe that we should be able to put forth our expert opinion and that the appellant should not be able to do so.
Thank you.
Thank you, Your Honor.
To address the point, there's no dispute on whether it was a 2x4 or a 4x4. It is undisputed that it was a 2x4. It is the forwards expert relied on plaintiff's position that not using a 4x4 is a defect. It is our expert's position that that is incorrect. You can use a 2x4. We're not conflicting. We would be precluded if our client came in and said the stand was in perfect condition, there was no defects. We can only.
Well, that's essentially what you're saying. Your expert is saying it should, it's a 4x4, right? So it's essentially, it's a distinction without a difference, right? What you just said.
No, our expert is not coming in saying it was a 4x4. We agree that it was a 2x4.
Right.
Our expert is saying a 2x4 is a proper stand. That is, their position is a 2x4 is not a proper
stand. Right.
It's an opinion based on agreed set of facts. Their opinion is wrong because their expert opinion is incorrect. That is our position. That is the fact.
So if it's your view that that creates a material issue of fact,
Yes.
and that summary judgment should not have been awarding them summary judgment on a 200 claim,
Yes.
then it should go to the jury trial, go to a jury so that the jury can hear, we agree it's a 2x4 and it was a good stand, correct?
Yeah,
That's what
everybody
you're saying.
agrees that it's a
So
2x4.
isn't that evidence? Wouldn't that be trial evidence coming in by an expert looking at a picture, yes or no?
No. They're presenting the evidence that it's a 2x4.
No, sir. Your view is that most summary judgment should not have been denied. Should have been denied, correct?
Yes.
Which means you go to trial.
Yes.
Which means your expert comes into the courtroom before the jury and says, look, it's a 2x4 and it's a good stand. And it's not defective, correct?
Correct.
How would your expert be able to come into court with a preclusion order that bars that, which is what my colleague raised earlier?
We're not precluded from offering expert testimony. We're responding to an opinion that a 2x4 is not proper. There has been evidence that it's not disputed that it's a 2x4.
Thank you. We got it. Thank you.
It's not only the 2x4, it's also the fact of a missing bolt or pin, right? That's not the only issue in the case, is the size of the lumber.
The expert said
And you are
that
precluded as to that.
23-1.11 requires there to be 2 nails. And the court said that code standard does not apply and dismissed 241.6. They've already agreed with us on that issue. That was not appeal. They said, the expert said that this code section applied. We said it didn't, and they dismissed that part of the claim. So by that part of the decision, we are able to rebut expert opinion.
I still don't understand how you're able to get around the preclusion order that way. you're simply taking a backdoor way of putting in expert evidence by disputing what their expert said by your expert. If you were simply arguing about what their expert said, that would be one thing, but to put in evidence in your papers to rebut and dispute their expert seems to me a clear violation of the spoliation order.
I'm not disputing the
preclusion
condition
order.
of the stand. We agree that it's a 2x4.
You know, I think I'm hearing this over and over again. I got it. Thank you.
Sorry.
Sorry.
Next case, Doma Ascolo versus Board of Managers. Sorry. Not get the name out. Thank you. Go ahead, Counsel.
Good afternoon, Your Honors. We are seeking reversal of the court's decision dismissing the amended complaint of the appellants, specifically the causes of action for defamation, malicious prosecution.
So Judge Perry bases his decision on the following. I mean, this is what his decision comes down to at the end. After review of the charging documents, the moving papers, and the amended complaint, the court finds that plaintiff's allegations fall short of alleging actual malice sufficient to overcome the qualified privilege attaching to defendant's statements to the police. There is nothing in the record, particularly with regard to the charging documents, that would support an inference of actual malice sufficient to overcome the privilege afforded to defendant's statements made to the police. Where did he go wrong?
In the amended complaint, there are allegations galore in which, prior to the charging instrument, there were at least
It's
20.
not that there are a lot of allegations. Now, what are the allegations that make out the actual malice?
The fact that she stated that somebody was going to kill her, the fact that there were false statements with respect to what he was going to do.
When were those statements made?
Those statements were made according to the charging instrument, by email in June of 2019, I believe June 30th of 2019. Those allegations were specifically made for no other reason than to have my client arrested. They were protesting outside. The arrest wasn't because they were protesting. The arrest wasn't for anything other than they were upset.
Or were those statements made in order to try to bring the demonstrations to an end?
They might have been, but he was not arrested for any illegal protesting. He was actually protesting properly. And in one of the allegations, she said he was banging on the door and then threatening her. That would have been in direct violation of a restraining order that had been issued because of the prior false
And when was
police
that
reports.
statement made?
I'm sorry.
When was that statement made?
That's made in the same charging instrument that was used with the email, which would have been, and I'm sorry, I don't have the exact date, but it was part of the charging instrument where she basically says he came banging on my door. She called the police. She tells the police banging and he's threatening me. He couldn't have gone to the door. He couldn't threaten her. That would have been in violation, and we brought that out in our complaint and also in our papers. That would have been a direct violation of a restraining order that had been in place and at that time was still in place. It was later let go. In addition,
Is malice established just by your pleading that those statements are false?
those statements were false.
And
Were completely
is that
false.
your position that that's the malice then, that the statements were false?
The malice really comes in that those statements were not only false, but were specifically made to have him arrested because he was not doing anything else that could have possibly have had him arrested. The protesting was not illegal. It was not being done close enough to her. It had no threats yet. It had a bit of volatile language because they were upset. They felt they had been discriminated against. They had been thrown out of the building. This is a dispute between a building owner and the tenant, not even the owner of the apartment. The owner of the apartment was about to renew the lease when the building said no, and suddenly a slew of false police reports are filed. They file an action against the owner, alleging all sorts of things that did not happen, and then she has to sue my clients, but nothing ever happens. Basically, they let him go. He's basically thrown out of the building. He leaves. And after he leaves, he realizes how much discrimination took place, and he begins to protest. And the protests have no issues whatsoever. All of the allegations that arise in the amended complaint arise after the employment of one employee of the building's managing agent. And everything goes downhill from there.
This is the Whipple person.
Yes, Kellyanne Whipple. Before that, the amended complaint notes, no complaints, no problems. He's helping people in the building. She gets hired and something happened. It's unknown. But 21 false police reports are made. He's never charged. He's never warned. Nothing ever happens to him. He goes to protest, he gets arrested, and there's no other reason for the arrest except for the statements that are contained in the charging instrument. And those statements are false, I believe.
So the amended complaint doesn't specify when these statements were communicated to the police, does it?
It does not. It only shows up in the charging instruments. But we can't.
But there's no allegation as to a date on which they were made?
No, we don't know when they were made to the police. We only know the date of the arrest, and we know the date of the charging instrument, and that's it.
Okay, thank you.
Good afternoon, Your Honors. Craig Kesh for the defendants, respondents.
So why don't those allegations as set forth by appellant's attorney satisfy the malice requirement for defamation?
Oh, well, several reasons. Because, as was stated in the complaint, and as my adversary conceded here, all of this, as she called it, allegations galore, had nothing to do with the arrest that is the subject of this action. The arrest...
It's not necessary for the defamation claim to survive, is it? If they're false, why isn't that enough for the knowingly, and the defendants knowingly made false statements, whether or not an arrest follows, isn't necessary to set forth the defamation claim, is it?
That may be, Your Honor, but two reasons. One, they don't make any allegations here. All they are saying is that the arrest arose out of the charging instruments. If Your Honor's question...
No, they said that the statements that were made in the charging instrument were attributed to your clients.
Right. I just want to make sure that I'm addressing, Your Honor.
So why wouldn't that be sufficient for the defamation action?
We're talking about the allegations that are in the charging instrument itself, not the additional extraneous allegations. That's the question? I just want to...
You can start there.
Okay, sure. For a couple reasons. Because the standard was not met. The particular words were not said. The date, time, place, and matter, when it was made. All the charging instrument says... Well, let me actually back up a moment, Your Honors. We've got two charging instruments.
What requirement for a defamation action to set forth the date, time, and place they were made?
Yes, it is. It is, Your Honor. This court said so in the Dillon case, 1999, also the Offer case, OFFOR, 2019. It is, absolutely. Additionally, though, even if the charging instrument had alleged all of that, there's a privilege here. These are statements that are made.
It's privileged unless there's malice.
Yes.
And malice is an intentionally false statement made, correct?
Yes, however...
Okay, so Bree, so if those statements that were made by Ms. Whipple, that were part of the charging instrument that the police relied on, these threats, et cetera, to arrest him, and they're false, isn't that defamation?
No, Your Honor.
If they're because they're not intentionally false?
No, because when...
Because the plaintiff wasn't in a position to say when Ms. Whipple told the police these statements?
Even if he were, the answer is that the complaint does not sufficiently allege malice. All it is are conclusory statements which are insufficient to overcome the privilege. And that's exactly what the court said, which is that the content and the context of the statement...
Says that he said he's going to kill me. Why isn't that specific enough? If he says that, if Ms. Whipple says that he said he's going to kill me and that's false, why wouldn't that be a sufficient allegation?
That's actually not the allegation that the plaintiffs are complaining about. What they are complaining about is one specific allegation in the July 17th, 2019 charging
That
instrument.
wasn't a good fit to the building?
Excuse me, Ron?
That the plaintiff was not a good fit for the building?
No,
No,
it's
the
the one.
statement was that he was banging on the door and said to her in substance, "I'm coming for you."
Yes.
Is that it?
Yes, Your Honor.
All right. So that allegation with the additional allegation that that's false, not enough.
No,
Why not?
because
What's missing?
what's missing? First of all,
Aside from time and place,
okay.
we recognize that may be something. But what's missing in terms of establishing malice?
Oh, because you cannot establish malice simply by saying that it was made with malice, and that's exactly
No, that it's false. They said that they didn't say it was made with malice. They said that it's false. Is that enough to establish malice?
absolutely not.
Why not?
Because first of all, because there's a privilege that a forged
The
statements that are made
privilege
to the
is undone by malice. So
no
what we
either.
circulate here.
But however, Your Honor, even if the information turns out to be false, statements made by individuals to law enforcement are accorded the privilege. That's the
Not
present.
if they're made maliciously.
Not if they're false.
But if they're knowingly false, right?
Yes, but well,
Well, first of all.
But the complaint would have to say
Can you
that.
infer time and place?
excuse me, Your Honor.
Can you infer time and place? So if a person is arrested on June 1st, and the charging instrument that led to the arrest says that I was threatened by the defendant, and you can infer that those threats were made at the subject property, the condominium, by the office there when he was banging. And let's play it out. And within 24 hours, they arrested him. I mean, I'm making a whole story here, but it's not, it's a pleading. And one can't one infer all this information from the charging instrument?
I would say no, Your Honor, because not even the plaintiff can keep the story straight, because she says, the plaintiffs say, the statements might have been made beginning on or around June the 30th, because there's another
It starts
email.
in February, doesn't it? It starts the.
That's what they said a different time. First they say June 30th, then they say it might have been February. Now, the February, Your Honor.
But this is not a situation where you know these statements were made some hours before the police executed their arrest, because this is over a many months period of time.
Well, according to the complaint, the statement, or rather the charging instrument, is dated on July the 17th, and the arrest was made on or about July the 18th. Now, as to Your Honor's question, the February point would be an issue, absolutely, because there's also a statute of limitations issue here, okay? Because the complaint was filed on January 6th of 21, so any allegedly defamatory statement would ordinarily have to have been made by January 6th of 2020. We have accounted for the toll for the COVID pandemic, and so that backs up any statement to be on or after May 23rd of 2019. Plaintiff himself is not even sure, and they sort of flip-flop and say, oh, well, the allegations were maybe made to the police in February, and then they back up and say, no, they were probably made beginning on or about June the 30th, and the only basis for that is another email in the charging instrument, notably the veracity of which they do not dispute. A lot has been said, Your Honors, about the allegations are false. Okay? In point of fact, there's a clear record here that what has actually been going on. And the restraining order that the plaintiff referenced, I should mention, the site for that is page 138 in the record, and it shows that that was signed November 19th of 2019. After this.
Okay, thank you.
Thank you, Your Honors.
Your Honors, the only.
Was the statute of limitations issue dealt with below? Was the statute of limitations issue addressed below?
It was addressed below, and the statements that are relied upon are after the May 2019. The complaint, I respectfully disagree that the complaint is not as specific as it can be based upon the charging instruments and based upon what
So
was
there is
said.
a requirement to give the date, time, and place of the statement. How have you satisfied that requirement to give the date and time?
Time is an issue. There's no doubt about that. But dates are based on what was in the charging instrument. The charging instrument says emails between such and such a date and June 30th, 2019. In the complaint, it says prior to the July 2018, there's a report from the police department dated July 10th, 2019. That's a very specific date. The time, we can't give because the police report doesn't necessarily give all of the information that we can to put into the amended complaint. We followed the charging instrument, the email, and the police reports that were timely in order to assert that these were defamatory false statements. There's also, and there has been an argument made that the action was that the criminal complaint was dismissed due to a speedy trial. It was dismissed due to a speedy trial because the respondents did not provide any discovery despite numerous requests to provide discovery of the very charge that they were alleging had all of the instances that...
Which means that they didn't pursue the charge against you.
They didn't pursue, but they also didn't dismiss voluntarily. They just simply didn't respond. They just...
Well, it's not up to them. That's for the court to do.
Well, our client's attorney at the time made a motion to dismiss based upon the lack of discovery. But that only goes to demonstrate that they wanted revenge against my client. They wanted to do something to harm him, and this criminal complaint was simply an effort to silence him and to harm him.
Thank you. Thank you. Greater New York Mutual versus Canali Insurance.
Good afternoon. May it please the court. Patrick Lawless for the appellant, Kinsale Insurance Company. This case, these disputes are clearly governed by the unambiguous arbitration provisions of the insurance policy. The arbitration provision says that all disputes over coverage, including whether an entity is an additional insured, shall be submitted to binding arbitration. The fact that Greater New York or its insureds are not signatories to the policy is irrelevant because they are actually seeking the benefit of the policy as additional insureds, and are seeking to enforce the policy. So they can, on one hand, claim they're entitled to all the benefits of the policy, while on the other say we're not bound by its provisions. The other arguments that Greater New York presents why the arbitration provision shouldn't be enforced are equally without merit. They claim that Kinsale somehow waived the arbitration clause by disclaiming coverage. That is clearly contrary to the law of this court in the Kensington decision, which said a disclaimer of coverage doesn't waive arbitration. Greater New York also says that the service of suit provision somehow conflicts with the arbitration clause. But the service of suit provision, all it is a consent to jurisdiction.
It gives a forum to be able to enforce the arbitration.
I'm sorry?
It just gives a forum.
Yeah, exactly.
In Article 75.
It just provides a forum to enforce the arbitration provision, but it doesn't bind the parties to a particular forum as the arbitration provision does. The arbitration provision clearly says that any disputes over coverage shall be submitted to binding arbitration. So there's no conflict there. And the other arguments that they present that the arbitration provision wasn't disclosed to them timely, they're without merit too. As soon as Kinsale became aware of litigation, it informed Greater New York of the arbitration provision. They didn't take any steps to waive arbitration. There was, they didn't consent to litigating the court in Supreme Court and then change their mind. There's none of those elements of waiver are present in this case. And unless the panel has any questions, I'll reserve my arguments for my reply.
Thank you.
It pleases the court, Mike Chuvin for Greater New York Mutual Insurance Company.
What is your response to your friend's point that you're seeking the benefit of the policies without accepting the obligation, namely to go to arbitration?
Your Honor, we are seeking the benefit on the policy. That's not disputed. But because we're a stranger to the policy, non-signatory, it has to be clear and unambiguous. That's what the law is. So
But if you're seeking benefits under it, why aren't you bound by the entire language of it, not just the parts of it you like?
we are bound by the parts that would apply if it was clear and
Why
unambiguous.
doesn't the arbitration clause apply to you as well, once you're seeking the benefit of it?
Well, because it's not clear and unambiguous, Your Honor.
It's clear and unambiguous that you're seeking the benefit of the policy, so why doesn't that get you there?
Because, Your Honor, we're seeking to have money paid to us that wasn't paid, right? And if you look at the service of suit, it specifically says that. That's the first line of it. It says, in the event the company to pay an amount claimed due under this policy, that's what our complaint alleges. They owe us money due under this policy.
That's the issue, and therefore that's an issue subject to arbitration.
No, Your Honor, I read the service of supervision. So they're saying, if I say there's money due under this policy, they consent to the jurisdiction of any court of competent jurisdiction. It's exactly what we did.
That doesn't overcome the arbitration provision. That just means they agree to jurisdiction of any court to enforce the arbitration ultimately. It doesn't necessarily mean that it doesn't, I don't see anything in there that says that they're waiving arbitration.
Well, Your Honor, if you look at the cases, Nika, Montauk Oil, that actually address the service of supervision with the arbitration, there's other cases that deal with the opposite, right? And when you look at those cases, if you focus on where it is in the policy and how it's read, it goes arbitration provision, then service of suit provision. And the reason the courts found them that it supports one another is because the arbitration provision comes first. It says, this dispute clearly and unambiguously should apply and go to arbitration. And then it says the service of suit provision would then provide a forum, as Your Honor said previously, for them to enforce the arbitration provision. This is different. If you go to the actual endorsement, the service of suit provision appears first, and it says, if you're alleging failure to pay, we consent to any court of competent jurisdiction, and that's what we did. We brought it in New York Supreme for the very reason. And that's why there's an ambiguity, Your Honor. We brought it in the court of competent jurisdiction for which they allowed us to do, and now they're saying, no. You cannot rely on that service of suit provision. You can only rely on the arbitration provision. Your Honor, there's a clear ambiguity in it. In fact, the second sentence of that
I mean, how do you respond to, I got a note here that's for myself, that there's a federal case that has the same issue that came up, that ruled against you.
Correct, Your Honor.
And how do we jive with that? I mean, how do we reconcile that?
I'm sorry, I didn't hear the last part.
How do we reconcile that? I mean, the federal courts didn't buy your argument.
Your Honor, there were three judges who've looked at this. Southern District, New York, Judge Knock, and Judge Frank.
Right.
We have three judges. Two have found it ambiguous in light of the service of supervision compared to it. One has found it unambiguous. So, Your Honor, it's our position, obviously, that the Southern District got it wrong on that.
Okay.
And, Your Honor, I was involved in that, so I can tell you it's my position they got it wrong, too. We didn't have oral argument on it. And it's under a different standard as well, because the FAA is kind of what governed that decision. When you read it, he cites to Article 4 of the FAA. It is the Federal Arbitration Act that really puts those cases in there. It's not the same here. It's a different standard. So I do think it's going to be a different analysis, which is why I do think Judge Frank and Judge Knox's decision is on point.
So, you know, these kind of disputes happen often, right, between insurance companies. So if I were to agree with you, wouldn't we be opening the floodgates to this kind of dispute? I mean, every insurance company is going to go and say, look, we got a boom here. Let's go for this. We don't have to go to arbitration anymore, because this is sort of an industry thing that we're going on, right?
Well, Your Honor,
where there's an arbitration clause, two insurance companies are going at it. The best place to go under these policies is go to arbitration. But if I were to buy your argument, that's no longer going to be the case. It's going to literally, the exception is going to swallow up this rule. There's going to be no more arbitration, because any way you want to word it, it doesn't matter. As long as you have the service, what is it called? The service?
Service of suit, Your Honor.
Service of suit provision in there, we don't have to go to arbitration. We're good to go.
Your Honor, if you don't mind, my argument's a little different, and here's why. One, it's not an ISO form. This is not an industry-wide standard. These are specific terms. If you look,
there's enough policies that have this service for suit in it, right?
They have different language, Your Honor. And that's where we want you to focus, is specifically on the language of this service of
Is
suit
it the language, or
provision.
is it where the service of suit appears, that it appears before the arbitration?
That's one of our big issues, because in the, again, Nika's cited, Montauk Oil, if you look, they come after the fact, so it works together. Whereas, and I could give Your Honor two citations to look at that support it, 963 SW2D 392, and that's the Transit v. Lloyd's case, and 1997 U.S. District Lexus 8264, that's the Theocal case, and what they say
Where
is...
is that from?
I'm sorry?
Last one, where is that from?
District of Utah. And what they say is...
And we should be bound by that because?
It's in Utah, as opposed to
I'm not saying be bound by it, but the reasoning. If you look at the reasoning, they say you're an insurance company, you're seeking to bind others. It's got to be clear and unambiguous. If you want that service of suit provision to work together with the arbitration clause, just say it. And that's what we're saying. It's not even referenced. You have the service of suit, then the arbitration. It is ambiguous to us.
Okay, thank you.
Thank you, Your Honor.
I'd just like to,
If you were to prevail here, what's the relief that you're seeking? Is it a stay or dismissal of the action?
well, we're seeking, I mean, the relief is seeking either or, either dismissal of the action or
Satisfied either way.
compel the parties to go to arbitration and stay the action. So that's the relief that's being sought. But I'd just like to point, I rely on my prior arguments. The service of suit is not a forum selection clause. But I'd just like to point out that according to the decision of this court in the Kensington case, which is cited throughout my brief, that's 122, 83rd, 537, it says, and the argument that Greater New York is stating is that it's ambiguous. The arbitration provision is ambiguous. And what Kensington clearly says is, it says in that case that the arbitration clause was not ambiguous, but if there is any ambiguity, it's to be resolved in favor of arbitration. And that's the law of this court, and that's what this court should affirm.
Well, yeah, I mean, the Kensington case that you're referring to is just simply states that you can't seek coverage under the policy and at the same time not be bound by the provisions.
Yeah, exactly. That's the same.
Pay me under the policy, but I'm not going to follow the rules.
Exactly.
Okay, thank you. Thanks. People versus Randy Paulino. Oh, I'm sorry. Oh, hold on a second.
You're right.
Okay. Thanks. I got good wing people. Thank you.
Good afternoon, Your Honors. Graham Ball on behalf of Appellate Mr. Paulino. For almost 30 years, Mr. Paulino has successfully managed his serious mental illness in the community, and this case is his first and only contact with the criminal legal system.
Counsel, to just jump right into it, in terms of what justifies a sentence reduction, was he conferred a huge break, whatever you want to call it, to begin with?
Your Honor, I disagree. I don't think that he was conferred a huge break. Some of the reasons that we are asking for you to reduce his sentence is he does not have a criminal record. This is his first and only contact. His serious mental illness, along with his very traumatic childhood upbringing.
These are all things that the sentencing court knew, correct?
Your Honor, yes, these were before the sentencing court, but in the cases cited to in our brief, this court has previously looked at factors that were before the trial court and have reduced the sentences.
Can you lean into the mic a little bit more? I can't hear you.
Sorry, my apologies.
There you go.
Thank you.
Well, your client had huge exposure if it ever went to trial, correct? And you do not minimize in any way the heinous nature of the crime, vicious assault that rendered someone, I guess, in need of care for the rest of his life.
Yes.
Can't dispute that, correct?
Right. We don't dispute the deeply traumatic.
So, given the exposure of more than 8 years, why isn't the 8-year sentence a gift?
Your Honor, his serious mental illness, the impact that incarceration is likely to have on someone who is seriously this mentally ill. We're not trying to say he shouldn't be in prison. We're just saying that this sentence.
He's also a serious threat to public safety if he's off his medicines.
Your Honor, this is sort of a one-time inadvertent lapse. He hadn't had his medication 5 days before.
How did it, what transpired with the plea judge in terms of what the sentence would be? There was a representation made to the plea judge that the people were asking for 10 years. Was that a conversation just between the judge and defense counsel, or was there a district attorney present too?
There was a district attorney present. My understanding is that this was, the defense counsel may have made a miscommunication to the court about what the offer was.
So why didn't the district attorney know what? Was it a district attorney who had not been assigned to the case, who was just standing up, or?
My understanding is that the original district attorney who had first appeared had left to go.
Was that because she was having a baby?
Yes, that's correct.
So was someone else standing up at the time of that conversation?
I believe so, yes.
And that person said nothing?
Nothing until later, until after he had taken the plea.
So why is, okay.
Thank you, Your Honor.
Okay, thank you.
May it please the court, Rafael Corbello for respondent. To pick up on the last line of questioning, the originally assigned ADA went on maternity leave.
But that doesn't excuse the ADA who was there from saying, Your Honor, I can't confirm if that's true or false, can we recall it? Or saying, Your Honor, I need some time to get back to you about this. It doesn't, the fact that the ADA, it was not the ADA's case doesn't excuse that person from speaking at all.
Well, the newly assigned ADA did speak up at the plea to mention that the people's offer was actually 15 years.
That's not in the record before us. At the same conversation?
That, he's referring to a conversation that's off the record.
But at the conversation that was off the record, was someone present from your office?
I have to assume so, yes.
And so there's nothing in the record that indicates what that person said, right?
Correct.
So shouldn't we assume that, in fact, that's really on that person for not opening his or her mouth instead of saying it's the, I mean, there's no question defense counsel made a mistake, which is unfortunate, but shouldn't it then be the responsibility of your office to say something?
Defense counsel was relaying to the judge a conversation to which the newly assigned ADA was not privy. And so it would require the newly assigned ADA to assume that defense counsel must be lying. And so why
you know,
would...
it happens all the time where you have a newly assigned and they'll say, Judge, I have to get up to speed. I don't know. I can't confirm that. But to sit there, to stand there silent, it's not carrying out your duties.
Because the newly assigned ADA had no reason to believe that defense counsel was saying
But that aside, the newly assigned ADA, you know, it's important that you say newly assigned, because I wasn't sure if it's newly assigned or just someone standing up in place. But if it's a newly assigned, she must have formed an opinion as to what the case was worth.
And she said, Your Honor, on the record, she said that the people...
We're not talking about the on-the-record conversation. We're talking about the apparently off-the-record conversation.
Well, that requires a lot of guesswork. I don't know what...
It seems that this really doesn't matter in terms of the issue in front of the court now, because whatever transpired, it worked for the defendant's benefit.
Can you, in a few words, tell me why should this sentence not be reduced?
Well, defendant is saying that he doesn't belong in Group A with defendants who commit violent crimes. He belongs in Group B with defendants who commit violent crimes but have mental health issues. So let's look at the cases to see how defendants in Group B have been sentenced. And those cases are the cases upon which he relies.
Why don't we look at this person's history, namely that for 29 years he had no contact with the criminal justice system, which is unusual.
It's similar to the cases that he relies. The defendants in the cases that he relies were in similar situations, mental health issues.
But in those cases, if I remember correctly, there were some of them, there were multiple victims, and in others, they involved weapons.
Well, in Reyes, for example, that was very similar to this case. And
that involved a machete, didn't it?
I'm sorry?
That involved a machete, didn't it?
It did, yes.
That's very different, right?
But here, the defendant punched a 72-year-old man over 40 times, so severely.
What condition did he leave him in?
He needs to be in medical help for the rest of his life.
Okay.
He was charged
There's
with.
no doubt that I think as a starting point, we all agree that the crime is heinous.
Yes.
Heinous.
Yes.
That doesn't mean that it doesn't get reviewed for reduction, right?
If the sentence is harsh and severe, of course
And
it
to
gets
determine
reviewed.
that, you look at the facts and circumstances of this case, right?
Absolutely, but you
And when you're
need.
comparing it to Reyes and the others, where you had a machete in Reyes, and in the other case you had two victims, one of which was thrown in the river with a broken jaw, right? Those are distinguishing factors that are not here.
But you need some frame of reference, and so when you pummel a 72-year-old man by punching him over 40 times and leaving him in need of medical care for the rest of his life, that there's no debate.
But we have to use that frame of reference relative to the facts of this case. One of the facts that I was surprised by was that this crime was reported by the defendant himself, who called 911. And from the hundreds and hundreds of criminal cases I've read since being on this court, that's an unusual circumstance. Wouldn't you agree?
I agree, and he was
And
exposed.
therefore, and that's something that suggests that this man was not an evil man. He had medical problems, and he was delusional.
Fair enough, Your Honor. He was exposed to 25. The people were going to offer 15. The judge thought the people were offering 10. We came down to 8.
Let me ask you this. What good do you think it will do this defendant to be in prison for 3 more years? How do you think, I assume that our goal in all of this is to bring this man back into society in a way where his mental health problems are dealt with in a way where he will no longer commit crimes. How do you think that will be accomplished by his being in prison for 8 years instead of 5, or enhanced? How do you think it's likely to make that result more likely if he's there longer?
Your Honor, there are multiple prongs to the criminal justice system and the punishment that is dished.
I'm not asking, I'm asking you how you will accomplish, how the ultimate rehabilitation of this man will be accomplished or enhanced by keeping him in prison for 8 years instead of 5.
That's an impossible question for me to answer. I cannot possibly know the answer to that
Does
question.
incarceration also serve the purpose of public safety?
It does, and retribution as well. He may never be rehabilitated. I don't know.
Okay, thank you.
Just briefly, Your Honor, again, we're not trying to minimize the severity of the conduct here.
Is there something particularly aggravating about one person punching another person who's 72 years of age in the head and the face with his fists? Is there an aggravating aspect of that sort of beating?
I guess the other, to add on to that question, is we have the Reyes case where there was a machete involved. That was a weapon, clearly it was a weapon, but in my mind, as Justice Friedman is saying, when you're pummeling a man with your fists, I know there's a knife, there's a machete involved, and there's hands involved, but the injuries, how do you...
We aren't saying that he shouldn't have served time. We're just saying that 8 years here is a bit
But isn't there a view that there's something particularly aggravating about one person punching another person who's 72 years of age in the face and in the head more than 40 times? Yes, having a machete means that you've come armed. There's that aggravating aspect, but there's perhaps an equally aggravating aspect that you, with your own hands, just keep on pummeling, punching, and punching another human being?
I don't know if I can say that it's equally aggravating, but I would agree that it's violent.
Counsel, is there any literature that your office relies on with regard to whether a longer stint in prison what impact that has on somebody with mental illnesses similar to those of defendant, who apparently at the time he was committing this awful crime thought he was God?
Yes, Your Honor. The study cited too in our brief, we show that the impact of incarceration on someone like Mr. Paulino, who's been diagnosed with schizophrenia, bipolar, schizoaffective, major depressive several times by several doctors, is just going to exacerbate his conditions while he's incarcerated.
Okay.
It's going to make things worse.
Thank you.
Thank you so much, Your Honor.
Nostrin, 45 Nostrin LLC versus Strongen.
Good afternoon, Your Honors. May it please the court. Jeremy Honig from Rifkin Radler for the appellant. Plaintiff's cross motion for an extension of time to serve the complaint should have been denied. While the Supreme Court tacitly agreed that plaintiff failed to establish timely and proper service of the complaint, instead of dismissing the action without prejudice or ordering a traverse hearing, the Supreme Court wrongfully found good cause to extend plaintiff's time to serve the complaint. This was an abuse of discretion for a number of reasons. The process server's affidavits of service contain
Let me ask you a question, you know, with this service of process issue. Was there a statute of limitations problem? So had the court ruled against, could they have served it again?
Absolutely. This case...
Yes, they could have served it again, right?
100%.
So, I mean, you know, at the end, you're just delaying the inevitable. They're going to serve your client again with a suit again, right? So,
well, Your Honor, that I understand your argument, but we have these rules for a reason.
Don't get me wrong. Don't get what I'm saying throw out the CPLR. I'm not saying that. But I think for me, the heart of the issue is the specific performance claim, right? Is that viable or not?
Well, we'll get right to the specific.
All right, let's get to the merits.
I like that, Your Honor.
Thank you.
It's not a viable claim. The case law on specific performance is clear. It's legion in every department at the Court of Appeals. When a party is claiming that the other party repudiated the contract, they have a binary choice at that point. They could do two things, and those are mutually exclusive things. Number one, they can immediately declare that a default, and they can sue for their remedies. They can go after whatever the contract allows them. They can go after, or they can go after specific performance if they want at that point. Or they can reject the repudiation, keep the contract in place, and then if they do that, both parties have to continue to perform under the contract. That is what the case law says. What we have here is the Supreme Court found that there was a repudiation.
So in my mind, a repudiation would be a situation where the repudiator does something that makes it impossible for them to perform.
I agree with you, Your Honor.
So in this case here, a repudiation would be almost in a sense that you sold your property to somebody else.
Sold property, it doesn't have marketable title, it can't be insured. Whatever obligations on the contract couldn't be performed.
So there wasn't really a repudiation here, right? I mean, it was more like, you know, I don't want to sell this anymore. And the buyer says, the buyer's lawyer sends a letter saying, time is of the essence. We picked this date as the closing date, show up. And then they get a letter saying, we're not showing up, right? We're not coming.
They didn't get a letter. There's an allegation that there was a telephone call from
the broker.
Not me, a different counsel for my client.
But from counsel.
From counsel. And the allegation in the complaint, in the amended complaint rather, is that that counsel said, it was first they had a settlement discussion that was, whatever. And then the statement that they claim is, we're not showing up and you don't have to show up. Now,
you being the plaintiff.
You being my client.
No, your client says,
that you don't need to, we're not showing up, you don't need to show up. Now, putting aside for a second that we dispute what was said, for purposes of this motion, we understand that we have to accept their version of events. If that, and putting aside for a second that may not be a repudiation, let's say that it is for purposes of this motion. They then had to make that election that I talked about before. And the letter that's on page 36 of the record.
No, for specific performance, my understanding is one side's got to show they're ready, willing, and able to perform.
That is correct.
And didn't they, and according to my notes here, and correct me if I'm wrong, they paid everything. They made 2 more electronic transfers to pay up the balance of what was due on this property, no?
It's not that they just have to be ready, willing, and able.
But no, but correct me wrong, they made a 10% deposit, and then they made 2 electronic transfers. They didn't make any transfers?
They claim that they made
They
transfers.
put the money in escrow.
According to them, we don't know. I know
But
that.
we have to accept that for purposes of
Agreed,
this motion.
but that's irrelevant here, and I'll explain why.
How's that irrelevant? Because you pay, I buy a piece of property for what I can afford, $100. I put $100 in escrow, I paid for it, I'm ready, willing, and able to finish this deal. You tell me that I'm not showing up, and you shouldn't show up. So it's futile for me, because obviously the next thing I'll say is, I'm showing up. But that's futile in that sense, right?
No, Your
Especially
Honor.
when it's not around the corner, but
In Shelter Island.
The principals are all in Manhattan, and the
But Your Honor,
take a
the
boat.
closing is in Shelter Island.
that would be true if they had said, that's an anticipatory repudiation. You're in breach right now because you told me you're not showing up. If they had done that, I agree with you. At that point, they don't need to show up. They elected, and it's in their letter on page 36 of the record.
Right.
Purchaser, this is after the phone call, this letter. Purchaser remains ready, willing, and able to close tomorrow, which means this contract is still in place.
Yes.
The case law says that if you make that election,
Yes.
both parties have to perform.
Okay.
Perform, when you set a TOE closing date, means to show up.
Okay.
And actually close.
Do you have to show up if you're told don't bother?
Don't bother?
Absolutely, because...
Okay. You got to take a boat to this place.
We have to be realistic and practical in the way we interpret what that means. And to be required to show up at somewhere where the other person has said they're not going to be is,
but Your Honor, you have
as
to-
they say
let me-
in their letter, is a futile act.
But look what it also says in their letter. It says, is prepared to appear at seller's counsel's office on Shelter Island at noon in order to do so.
Right, they say unless you could, but they won't do so unless you confirm by 9 a.m. tomorrow that you'll be there.
And then-
So why should they, I don't understand why that's not the same as showing up, really, because
Look.
you had every chance to get there.
Technically speaking, arguably, you're correct. The buyer should have, even though the seller says, don't show up, don't bother showing up because I'm not showing up. You know, arguably, technically, if you were following the letter of the contracts and dotting I's and cross your T's, the buyer should have showed up, just standing there with donuts and coffees by himself.
They had to show up, Your
They
Honor.
had to show up, donuts and coffee, okay? But
Did
like,
your
as
client
my-
show up?
No, my client did not show
So
up,
as
but
my-
Your Honor,
No, let me finish. And as my colleague says, you know, that's kind of like, you know, why are we going through all this exercise? Because, you know, it kind of like, it's futile, right? I mean,
no, it's not. If you look at the case law on
It wasn't like going around a corner to show up.
well, look,
no, you needed a boat.
Your Honor, this is an expensive piece of property.
Oh, no kidding.
If they wanted that property to make a trip
What
for
is it,
one
20
day,
million?
$10 million was the
I'm
purchase
sorry,
price.
I overquoted it.
So if they wanted that property, they could have. But it's not about whether they should have or shouldn't have.
Counsel, you're missing one point. They paid the entire $10 million into escrow.
But that's not performance under the contract.
Okay.
No, it is not.
I got it, thank you. Got it, thank you. Way over your time, thank you. Well, let's see what the other side have to say about this.
Good afternoon, Your Honors. May it please the Court, Jed Bergman of Glenager, Bergman, and Fuentes.
Is that
for
the rule that if you're told don't bother to show up, you still have to come?
It is absolutely futile. We cite 5 or 6 recent First and Second Department cases in our brief, making clear the law does not require futile
I mean,
acts.
what more
not
do you
distinguished.
want? I mean, what more do you want when you're saying, are you showing up? No, I'm not showing up. You don't have to show up either. But you
But
already
you have
know.
to be there, and you're penalized if you don't.
But on top of that, you've already put $10 million into escrow. I mean, am I missing something?
I don't believe you are, Justice Lang, except, if I may.
It was 20 million, right?
No, it was only, I don't want to say only 10. It's a lot of money for me, too. I'm the lawyer.
I got
But
maybe
no,
$100 at most.
The bit about the letter of the law did not require showing up because the letter of the law says that this New York law does not require parties to undertake futile acts.
Yeah.
And when the seller's lawyer says, don't come out to Shelter Island in January, in the middle of Omicron, by the way, we're not coming, you don't need to come. It is an exercise.
That water's
in-
awfully cold in January.
Yes.
Going across Shelter Island.
So unless the court has further questions on this, we'll rely on our briefs. And just briefly on service, it was clearly waived by the voluntary acceptance.
You know, and to my point, I mean, not that I want to toss a CPLR out, you don't have a statute of limitations problem. So, okay, you didn't think I didn't serve you? All right, I'm going to get it right the second time around.
Well, we tried 12
12
times.
times,
Oh,
right.
sorry. I forgot. Maybe the 13th time you get it.
Maybe the 13th would be lucky in this case.
Well, before you leave,
And the issue in any event is whether or not the trial judge abused its discretion in granting.
Exactly, under 306B, which there was no abuse of discretion here, and the decision below should be affirmed.
any further questions? Thank you.
Thank you, Your Honors.
Your Honor, the case law that counsel refers to on feudal acts, if you look at that case law, none of them are anything close to this. In every one of those cases, the court found it was feudal because performance was impossible, not.
Well, but here the performance was impossible if your client wasn't going to show up.
But
So why isn't that impossible as well?
There's a big
I mean,
difference.
if his clients schlepped out to Shelter Island and your client wasn't there, then closing the deal was impossible, right?
If you assume that my clients weren't going to be there.
Said
Well, you
they
just
weren't
said
gonna be there.
But there's
They
a,
said they weren't going to be there, so why,
And they, in
doesn't,
fact, weren't there, as
Well-
answered by my colleague.
why doesn't that make it impossible?
it's not, if you look at the case law on impossibility, it was that the government
For
didn't.
you know, impossibility is the wrong word to use. It's futile.
But,
like
but
anything else.
the case law of the quote-unquote feudal cases all talk about a virtual impossibility to perform. That's not what
Which
we
your
have
client
here.
created.
What's that?
Which your client created.
Your Honor, they created it as well, but if,
How did they create it? They put $10 million in escrow.
Because
and they
it's
were
what
ready,
they-
willing, and able to go.
Your Honor,
forward with
it's
this.
what they did after the phone call, not, if you look, they
You
had a
don't
tr-
want to know what they did after the phone call.
No,
You
I know.
probably didn't. They
No,
were
I know what they
happy.
did after the phone call. They said, we're not going to declare a default right now. We're going to leave this contract open. Let's hope they show up. And if they don't confirm, we won't show up. There's no obligation in the contract for us to confirm closing. On service, Your Honor, you only can find that they tried 12 times if you believe the process server. This process server lied, and it's
There's no good faith obligation in your contracts?
I'm sorry?
There's no obligation to proceed in good faith at all?
I don't think that, my client didn't do anything that was in bad faith. Every decision that the purchaser made was their own decision. They had an option after getting that phone call. What they decided to do was not go to the closing.
No,
not
actually, they
perform.
decided to not go to the closing unless they heard from you by night. They gave you an out, and you chose not to take it. They said, we'll come if you just give us a phone call, and then we'll be there.
There's nothing in the contract that requires us to do that. They've added this extra layer of performance that we weren't required to do.
It only got added because you told them you weren't going. But it's crazy. Like, why are we doing this circular? You're telling them we're not going. But they're asking you, we're not going to be there unless you're there. Please confirm. And then you stay silent, and now it's their fault for not showing up. It's maddening.
I'm not saying it's their fault. It was their choice not to show up. But I want to get to the service issue because
I'm sorry, isn't the service, doesn't the motion court dealing with that issue have a discretion?
they have some discretion, but there's case law
And
that,
why would it be abusive discretion in this case?
because there's an,
You have, excuse me, why was the granting of that motion in this case an abusive discretion, which is a very high standard?
there's an the affidavit of service from the process server says that he was there on April 29th at 2:22 p.m.
And 12 other occasions.
There was tons of noise in the house. 25 minutes earlier, my client was in a car accident, documented in a police report, 350 miles away.
Right, but there could have
No,
been
but
someone
that's not what the
counsel. There could have been someone else in the house.
The affidavit of my client says they live alone. Nobody else was in the
Could have
house.
been a house cleaner. I mean, there are lots of possibilities.
But they said there was nobody in the house. We have a process server.
How do your client said there was no one in the house?
My client says
How would your client know if they weren't there?
because they live alone. They don't have housekeepers. They don't have children who stay there.
Got it.
The process
Got it.
server lied.
All right, got it. Thank you very much. Thank you very much. Have a good day. Nunes versus SY Prospect. Okay.
Good afternoon, Your Honors. May it please the court. Stephen DeBraccio for the appellant, JJ Industries. The affidavit of Cesar Torres creates a material issue of triable fact as to whether plaintiff was the sole proximate cause of this accident. I want to clarify
Is
something
there a
the plaintiff
conclusory aspect to that affidavit? I mean, he's saying that he went up the wrong side of the ladder, and he told him not to go up, to go from the other side, but does he explain why it was the wrong side and the circumstances of it?
No, he does not. Mr. Torres did not explain why it was the wrong side in the affidavit itself. Defendant's argument is that basically under the Court of Appeals Montgomery case, the normal and logical response of plaintiff should have been to ascend the ladder from the upper step and not the lower step. By ascending on the lower side, this lower step, he essentially pulled the ladder onto himself when he was doing the painting in the stairwell.
So who explains that? Does Mr. Torres give us that explanation?
He does not state that explicitly in the affidavit.
So
No.
where does that appear in the record, what you just said? You described a scenario that he went up the wrong side and this is why. Where does that appear on the record?
It does not. I concede that there is.
Could you stick to the record? We'd really appreciate that.
Yes, Your Honor. Torres' affidavit establishes that had he, and the statement, he was concerned that he was concerned about plaintiff having an accident, establishes that had he ascended the ladder on the upper side.
So the picture of that ladder which appears in the record is not one which inspires particular confidence. I think he was going all the way up that ladder. It's not like he was on the first or second rung. Is the fact that the plaintiff was provided with that ladder sufficient to satisfy 241, or does this situation leave over the question of whether perhaps for the work that he was doing and the height at which he was doing it, something beyond that ladder, whether a scaffold or some sort of being attached with something against falling, whether to the wall of the building or something to, because there's really not much protection on that ladder when you consider, there isn't a base at the top of the ladder to hold on to, right?
Correct. That is correct, Your Honor. To that point, Your Honor, the mechanics of how the accident occurred is crucial to this case, and it demonstrates why another device was not necessary. Plaintiff testified that the ladder shook and then he fell as he was descending the ladder. In the Hernandez case from this court, this court granted plaintiff's summary judgment on the ground that the ladder was missing feet and that the plaintiff eliminated the possibility that it was his own conduct that caused the accident. Here, plaintiff's deposition testimony and the affidavit of Torres creates an issuable fact of whether it was plaintiff's misuse of the ladder that caused the accident by ascending on the wrong side.
So furnishing a ladder satisfies your 241 requirements, at least in terms of getting to an issue of fact?
I submit that, yes.
Let me rephrase that question. Was it enough to give the employee a ladder here, or did you need some further safety device?
No further safety device was necessary. The ladder was sufficient in and of itself to complete the task.
And how do we know that? Are you saying that that's as a matter of law, a ladder equals a compliance with 241? Is that what your position is?
No, Your Honor. I concede that the circumstances of each case dictate what safety device is appropriate. However, I draw on the case law concerning the realities of the commonplace of the work being performed. And here, plaintiff failed to establish that the statutory violation proximately caused his accident, in that he failed to establish that he was not misusing the device he was provided. And that, given that disagreement, summary judgment should have been denied. If there are no further questions?
Thank you.
Thank you, Your Honor.
First thing, counsel.
I need you to identify yourself, please.
Oh, I'm sorry. John Shore, and I represent the plaintiff respondent, Your Honor.
Thank you.
Thank you. First thing, the defendant cites to the Hernandez case that in that case there was missing feet. That's not the standard, whether or not a ladder was defective. As this court well knows, there's hundreds, if not thousands, of cases where if a ladder did not provide proper protection, irrespective of whether or not it was defective.
Defendant's point here is that Torres told the plaintiff to go up on the other side of the ladder, that he went up on the wrong side of the ladder, and that he told him to go up on the other side of the ladder. Why doesn't that create an issue of fact as to recalcitrant worker?
Glad you pointed that out, Your Honor. First of all, Mr. Torres said the wrong side of the ladder as he went up. As Your Honor noted, what does that mean? How is that an improper use of the ladder? What is the wrong side? We don't even know what the wrong side is, but conspicuous by its absence in Mr. Torres's affidavit, assuming he even explained that somehow he went up the wrong side, which we don't even know what it is. He never said he went down the wrong side when he descended the ladder, and that is deficient in his affidavit. Putting aside, there's no proof that there was anything done improperly here at all by the plaintiff. He went down the ladder, and the record is unequivocal and that the ladder first moved, and that caused him to lose his balance and fall. Conspicuous again by Mr. Torres's affidavit, he just said, I witnessed plaintiff's accident. Had he wanted to even dispute plaintiff's account that, oh, plaintiff just slipped or lost his balance, he never said that. He just conveniently said he had his accident. He never said he simply lost his balance. He does not controvert that the ladder moved. And the record is further uncontroverted that there was no scaffolding provided, and under the McCarthy case, no one was holding the ladder. No one disputes that. And the failure to provide a proper safety device for someone working in the middle between the second and third step, or in the middle of a second and third floor of a stairwell without anyone holding a ladder, without providing scaffolding, was clearly a proximate cause of the accident, and counsel has it backwards. I established my prima facie proof by showing that the ladder failed, it moved. And under the multiple cases in this court of Wasilewski, Marino, when a ladder moves, when it's not properly secured, that mandates summary judgment. And with respect to this, very briefly, with this compensation transcript that they submitted in opposition, first of all, it wasn't certified. Secondly, there was no proper translation or any proof that it was properly, that this translator had proper credentials in violation of Eustachio, and a recent case, the NASA case, 198 AD 3rd 606, a 2021 case. But even, let's say, it followed all those proper requirements. Again, under Marino and Wasilewski, same pattern. In Wasilewski and Marino, the defendant got testimony from the foreman in both cases, who said, plaintiff just told me that he slipped. This court, in both cases, says that's not inconsistent with the fact that the ladder first moved. There was no follow-up questioning. In this case, the transcript is certainly consistent. Plaintiff lost his balance. He said he lost his balance, that he was caused to lose his balance.
Okay.
It's the same set of circumstances as in Wasilewski and in Marino, putting aside they don't even get to that point because they didn't get a proper of authentication of the comp records, which was not certified, and then you get the proper translation in violation of the Eustachio case, unless this court has any
you,
other
counsel.
questions.
Thank you.
Thank you.
Your Honor, just 2 brief points on.
Counselor, Torres owns Master Painting, and he says he sees him going up on the wrong side. Did Torres have an obligation at that point to see that someone held that ladder until he was down safely?
I would say no, Your Honor. I would say no, given that he was provided a ladder and that plaintiff misused it, that that establishes sole proximate cause, at least tribal issue of fact as a sole proximate cause. The plaintiff misused the proper device that he was provided.
So his employer can see him doing something which the employer believes to be unsafe, and the employer doesn't have a duty to do anything?
I would say as a matter of 240, that is a distinction between the plaintiff still has to establish that his conduct was not the sole proximate cause of his accident, and plaintiff failed to do that here. One point on Your Honors, just to clarify, you asked about recalcitrant work. I just want to clarify that JJ's argument is sole proximate cause. Though we pleaded recalcitrant worker, that was not the basis of our opposition to plaintiff's motion for partial summary judgment. It was solely on sole proximate cause. And one other thing, plaintiff talked about the accident occurred as he was descending the ladder. And so the argument goes, well, I was following what my employer told me to do. Sure, but the test is not so much what the plaintiff was doing at the instant of the accident as when he was working. And I say that because of the Robinson case where the plaintiff used a 6-foot ladder instead of an 8-foot ladder and stood on top of it. The Court of Appeals emphasized the decision to get a 6-foot ladder instead of an 8-foot ladder. It wasn't so much about where he was standing when the accident occurred as that he chose to get the ladder. That he ascended the wrong side is why there is a tribal issue of fact.
Thank you.
Thank you, Your Honors.
FPG Maiden versus Bank Leumi.
Good afternoon, Your Honor. Stephen Mandelsberg from Thompson Coburn, representing the appellants on this appeal. This appeal raises critically important issues that affect commercial transactions, loan participation relationships, construction loan financing, and when a fraud claim that's really a contract claim should be dismissed because it's duplicative. There are 5 significant errors that the lower court made that justify reversal. First, allowing respondents to maintain a fraud claim that's barred by this court's December 2022 decision, declaring such claims duplicative of breach of contract claims. Second, permitting respondents to assert breach of contract claims against the party that has not signed any contract with them. Third, refusing to enforce an admittedly signed explicit waiver.
That's the 5th and 6th cause of action that you're referring about, allowing the breach of contract against BLITA. What you just said refers to the 5th and 6th cause of action? About the breach of contract.
6th cause of action.
About breach of contract.
A breach of contract.
Right. That's what the reference was.
That's the reason why that's
because they're not signatories to the contract.
They're not third-party beneficiaries. Refusing to enforce this consequential damages waiver, which was contained in loan documents that were admittedly signed by sophisticated parties represented by experienced counsel. This court, and Justices Shulman and Rodriguez, you may remember when I appeared here in November of 2022 on a prior appeal, one of the issues was to what extent fraud-based claims could be dismissed because there was no justifiable reliance based on clear releases. Okay, and here we have an attempt after that decision to serve an amended complaint that basically tries to, in certain respects, circumvent that decision. Fourth, sustaining a fraud claim that's barred by a broad contractual release. And fifth, exercising personal jurisdiction over a loan participant, Belita, the Bank Leumi of Israel, the National Bank of Israel, based solely on a participation agreement to which none of the respondents was a signatory or a third-party beneficiary, even though the amended complaint does not allege, as required by the long-arm jurisdiction predicate of CPLR 3302A1, that you must show a nexus between the claim alleged and the activity involved. These are the reasons why the lower court decision must be reversed. Now, let me turn to the first. The court really doesn't need to go further than its decision in December 2022, where you held, quote, to the extent respondent's fraud claim is based on a promise that the lenders would fund requests for advances if the budget for the building was out of balance. That promise is reflected in Section 8.4 of the Third Amendment. Thus, it is duplicative of the breach of contract claim. It's the same thing here. All they're trying to do is recycle a claim. They claim that it's collateral to the promise, but it's exactly the same thing. The claim for fraud is based on this theory that Belusa, the lender, was given instructions by the loan participant not to fund, when Belusa is the lender. And the other key issue that the court must, I respectfully submit, take cognizance of is how this complaint conflates loan participations and loan agreements. The participant here is not a lender. There's no reference to it being a lender. This decision would upend decades of precedent of this court and other courts that make a sharp distinction between loan participations. Every attribute of a loan participation is included in this loan participation agreement. Lita was not a lender. There's no reference to it being a lender. There's no incorporation by reference of any provisions. And the whole theory of the case here is that somehow Belita, the loan participant, told the lender not to make the loan, and somehow that's the fraud. But Belusa is Bank Leumi USA was a lender that was ready, willing, and able, and could have made the loan if possible. There was no dispute that it didn't have the ability to make the loan. And let me turn to a very important issue of the consequential damages waiver. Even if you didn't have a consequential damage waiver in the loan documents, you would be required to hold, as you did in 3 cases, which are cited at page 15 of our reply brief, that damages resulting from a construction loan contract can only be limited to the amount of money that the lender was supposed to provide but didn't. This was a construction loan. Belusa and the lenders agreed to provide up to $120 million of financing to build this Maiden Lane South Streetport building that has been plagued by problems since it started in 2015. And the damages that they are alleging, if they prevail, would be the requests for advances that would be made and were withheld. $90 million of financing had been extended pursuant to these requests for advances. And what's the request for advances that they say hadn't been made? Between $2 to $4 million. But their amended complaint seeks $165 million or $220 million based on a theory that they're entitled to the value of the building if it was built. There's no evidence and no allegation that these are joint ventures or partners. This is a lender under a construction loan agreement.
Their complaint does also state that your clients really didn't want to push them into default because of the adverse impact on their stock price.
There's no evidence that that's true, but Justice Friedman, even if it was true, it's irrelevant.
It doesn't hurt you.
What's that?
I said it doesn't hurt you.
It doesn't hurt me, but if I can finish, it's irrelevant because the contract involved here contained provisions that limited the obligation of the lender to make advances based on specific requests. Those requests are made, they're approved, and then they're made. Okay, so the amount of damages, even if there wasn't a waiver here, which there is, would be that amount. The amount of damages that they're seeking here is clearly consequential, lost profits, and it's clearly barred by precedent that this court has repeatedly upheld. Thank you very much.
Good afternoon, Your Honors. May it please the court. Jackson Davis from Cohen, Talbot, Spivak, and Wagner, appearing on behalf of the respondents.
I want to see if I understand one aspect of what your claim is. I mean, it seems to me that one of the things you're saying is that the fraud by defendants is that they assured you orally that Bank Leumi Israel knew about the Third Amendment and they were on board with it and they were going to go along with the considerations. They're not going to push you into default if you have shortfalls on some aspects. They're going to be looking, to put it simply, they're going to be looking to work with you. So this is a fundamental requirement, a fundamental representation that you wanted. Why, in negotiating the Third Amendment, why wasn't something to that effect put into 8.4?
Well, Your Honor, first of all, just to correct the record, the fraud claim is only alleged against
let's call it Valley Forge to make it simpler because we don't mix up the two Bank Leumis then.
So the fraud allegation is that there was
That Valley Forge assured you Bank Leumi is on board with this.
They're on board. And
Right.
based on that assurance, that's why FPG, the respondents, entered into the Third Amendment to the loan agreement.
So this was fundamental to your entering into the Third Amendment, and yet you put nothing about that representation into the agreement.
Your Honor, the entire point of the Third Amendment was to end this situation that had been plaguing the property, where there'd be a minor budgetary overrun in some area, and it would allow the lenders to stop funding the loan entirely as to other portions of the loan. And
then Bank Leumi doesn't go along with that.
That is correct, Your Honor.
And you say they told you that Bank Leumi would go along with that, and this was fundamental to the deal. And you know that Bank Leumi is providing half the funds for this. So why don't you get something put into that? I mean, just to try to understand this from a commercial sense.
Your Honor, is that the Third Amendment is only the only signatories to the Third Amendment to the loan. It's between Blita, it's between Valley
USA,
Forge,
yeah.
as we're calling it, Valley National, excuse me.
Valley National, BLUSA, and the other person, Hart something. It starts with an H. You guys got to pick easier names.
So the purpose there, they were the only two signatories to that document, and so the document only relates to the two of their own obligations.
Yeah, but as my colleague's pointing out, but it was fundamental to your client getting into the Third Amendment to have that assurance that there was going to be money coming in from somebody else. I understand that Blita is not in this contract, in this loan agreement, but Blita, in a sense, is it's a fundamental reliance that you're having, right? So that, you have the face of this release here, and then later on, you're saying you realize later on when you actually go and try to get the money's not there, and you're saying, oh, there's fraud. But wait a minute, fraud, it was all happening at the time that you were executing the Third Amendment. The fact that you found out later, well, you find out about fraud, everybody finds out about fraud later on. No one ever finds out beforehand, because if you do it beforehand and you sign the agreement, that's on you.
So the Third Amendment.
Did you get that? Okay, there was a lot.
Yes. The Third Amendment relates to BLUSA's funding obligation.
Yeah. No, I don't think we disagree about that.
The fraudulent misrepresentation was about a present fact about whether or not Blita understood and was aware of the funding
And I
obligations.
think in your complaint, you allege Blita didn't agree, go along with it. I think I saw
Oh,
that.
once they found out about it, they did not go along with it. And they didn't find out about it until 3 months later.
And that goes to the same point as my colleague saying that it's such a big, I mean, we're talking a lot of money here, right? We're not talking
Yes,
$100.
Yes.
Right? So
Definitely a lot of money.
it's probably all I have in my wallet is $100, but.
Counsel, if you can just clarify something for me. In the 2022 decision of this court, there was the dismissal of the first and second causes of action against Blusa et al. And parenthetically, there was the dismissal of the fraud claims against Blita, and that's why they never had to address the jurisdictional issue. So now you came back with an amended complaint, and your second cause of action has a fraudulent inducement claim against Blusa. So just humor me. What is the core distinction between the fraud claim, because earlier there were representations that you were going to fund them even if they didn't meet the TCO, temporary, or if there was going to be cost overruns or delays, all the stuff that they wanted, and that they would not, and they put in $20 million in the hope of getting this continuing funding for the building. What is the core distinction here? Is it what we just said here?
The core distinction is in the previous fraud claim that was dismissed, it related to an insincere promise that Blusa would comply with its obligations under the loan agreements. And this fraud claim is about a collateral issue of fact, whether or not Blita was aware of and understood.
Right. The other one, the earlier decision dealt with the TCO. Now you're dealing with the collateral.
So there's
that's where you change. That's the core difference.
Exactly. That is the distinction. So there's no allegation in the current fraud claim that Blusa. It doesn't relate to Blusa's obligations.
So as you've indicated before, we held it some duplicative, and you face a fundamental hurdle of how to get this panel not to find your fraud claim still remains duplicative. So this is what Valley National says about your claim about this. Blita's knowledge of Section 8.4 is relevant only as it relates to Valley National's contractual obligations. A fraud claim based on that knowledge fails no matter how respondents try to disguise it. If plaintiffs argue that Blita's knowledge or lack thereof of Section 8.4 somehow affected Valley National's willingness to fund advances, then as this court already held, this claim is plainly duplicative of respondent's breach of contract claim, which alleges that Valley National breached the Third Amendment by failing to fund advances. How do you get out of that point?
So, Your Honor, you could only have a duplicative fraud claim if it's asserted against the same party that the breach of contract claim is. So they're essentially arguing that the fraud claim against Blusa is duplicative of the breach of contract claim against Blita. You could only have, they could only be duplicative.
No, they're arguing that it's duplicative of the breach of contract claim against Valley National.
But it's not, because it's...
And we already so held.
It doesn't relate to what they're actually obligated to do under the loan. The fraud claim is about what they said.
Whether they've it relates, and I think that's the point of the prior decision. Did Valley National comply with 8.4 or didn't it? And to call it fraud, if they didn't comply with 8.4, you've got a breach of contract. If they did comply, you don't have anything.
And to piggyback on that, the end result is whether or not they complied with the contract, the 8.4, the lending obligations, the payment obligations. You're just changing how you get there. I mean, on the one hand, on the earlier case, you were arguing about the TCO. Now you're arguing it was collateral representation that you're seeking to be, that's fraudulent. But at the end, it boils down to why did they have a right not to forward you the money when it's out of balance in terms of the balance sheets, right? I mean, that's where we're at.
The difference, Your Honor, is FPG would not have entered into the Third Amendment if they had not been given this representation that...
It's the same thing about the TCO. the same thing. You wouldn't have entered into that Third Amendment if you weren't told that they were flexible on the TCO.
The difference with that is the TCO, that's part of the loan agreements, whereas the present statement of fact about BLITA's knowledge and awareness of the amended funding obligations, that's not something that's in.
You're just changing what you're relying on in terms of the representation. The first one you were arguing it was the TCO. Now you're arguing it was BLITA, or what was represented to you as to what BLITA was doing. But at the end, it boils down to did they have a right? BLUSA had a right not to make the payments, right? There's no. I mean. You think?
No, Your Honor.
Okay. All right. Any other questions? Oh, thank you.
Just a few points. Here is why this collateral issue is a smokescreen. This court, when it ruled in December 2022, that the claims were duplicative of the breach of contract claim, ruled that way because we presented precedent that basically holds, as this court has held many times, that when you're asserting a fraud claim that is in the guise of a contract claim, because it's based upon a contractual theory, you can't have that fraud claim. And that's why it was dismissed. So the fact that now they're claiming against BLUSA, where before they were claiming against BLITA, is irrelevant because the underlying principle is the point. Second.
Which is the payment.
That's right. Second, when I was here in November of 2022 arguing the appeal from the other decision, I believe it was Justice Schulman, or it could have been Justice Rodriguez, but one of you asked the question of predecessor counsel, how in the world could you justifiably rely on this section 8.4 provision where there were oral promises when you signed documents that said that there were no oral promises? And that's why Your Honors dismissed 3 fraud-based claims: fraudulent inducement, conspiracy, and negligent misrepresentation. Finally, there is no question here that the request for increased damages is barred by the consequential damages waiver. They've cited no case at all that says otherwise. And I would just remind the court to look at the 3 cases that the First Department has decided in 2015, 2022, and 2021 that are cited at page 15 of our reply brief, which clearly uphold waivers and have barred damages for loss of investment or the sort of damages that are sought here. And finally, I just want to point out that there's a lot of talk about Section 8.4, but the pleadings in the record make clear that my clients didn't withhold funding willy-nilly. They withheld funding because they were entitled to under the loan documents, because the building had not met various deadlines, and because 18 days after this Third Amendment was signed, what did they do? They sent a letter, March 31, 2020, saying that it's virtually impossible to comply with the deadlines that they had agreed to 18 days earlier in a building that had been initiated in 2015, and provided no date by which the buildings could be completed. If that isn't a good ground for refusing to provide funding after $90 million, I don't know what is. So, Your Honors, respectfully request the lower court decision be reversed and this court adhere to precedent that enforces loan participation relationships in this state. Thank you very much.
Seal versus City of New York. Last but not least, thank you. It's still daylight outside, so go ahead, thank you.
Good afternoon, Your Honors. If it please the court, Karen Wolf for the appellant, City and Police Officer Daniel Coy. Given the hour, I will be brief. This case involves...
Only 4 o'clock, it's okay.
Oh, I'm sorry.
It's only 4 o'clock, we're not at 6.
Well, I'll be brief
Thank you.
in any event because it's a relatively straightforward case. we believe. The case involves a police officer in the emergency operation of a marked police vehicle, which unfortunately had an accident with the plaintiff's car.
Counsel, I was curious, did the court ever give plaintiff's counsel permission to submit an additional affirmation or opposition to your motion?
Not that I'm aware of or that was reflected on the docket.
Okay.
And I
assume that orders are, we should assume that orders would be reflected on the docket.
It was my understanding, yes, that orders would be reflected on the docket. My only hesitation is I wasn't trial counsel, and so I can't state necessarily everything that was said in a compliance conference. But no compliance conference order or any other order on the docket allows for that subsequent affirmation, which was submitted by plaintiff. And I assume that's with respect.
Yeah.
Right. Just to circle back around, the Supreme Court's denial of summary judgment to the city should be reversed. The city has met its burden of showing there are no disputed issues of material fact. It's undisputed that the standard here is reckless disregard and not ordinary negligence. That's Vehicle and Traffic Law 1104.
So on this record, there was no meaningful refutation of the police officers' affidavits or explanation of what they did.
Yes, Your Honor.
Both the driver and the passenger sergeant with them.
Absolutely, Lieutenant Kim.
And they walked it through, and they're allowed to go through red lights and stop signs, but again, they had to exercise certain caution, and they described exactly what they did in terms of the speed limit and putting the brakes on and all that stuff. And on this record, there was absolutely nothing from the other side that refuted anything they said.
Absolutely, and I might be able to just sit down now. I think that's the most effective version of my argument I've heard. That's absolutely correct. It was not refuted on the record. What we see before this court is speculation and conjecture. It's sort of what-if scenarios, and the plaintiff's primary argument below and also before this court is the fact that the accident occurred is evidence of recklessness or disregard of, reckless disregard, and that, of course, would be an ordinary negligence standard and not the heightened standard afforded to emergency vehicles. Thank you, Your Honor.
Thank you. Good afternoon, Your Honors. Jason Steinberg on behalf of the respondent. The first thing I want to point out is the amended affirmation that you were talking about was submitted on October 15, 2014. And the decision from the court didn't come out until about a month later.
Right, but did you ever have permission to submit that amended affirmation?
The amended affirmation that was submitted was accepted by the court.
I didn't ask that question. The question I asked is whether you had permission to submit it.
Yeah, I'm sorry?
Whether you had permission to submit it.
There wasn't permission. There's no written permission, but there was no indication that we didn't have permission to do it.
Well, the CPLR says when there's a motion, then there's a motion and then an opposition and a reply, and that's it. So if you want more than that, don't you have to get permission?
I don't know that there's a CPLR section that says you need permission to submit a supplemental papers. I mean, on a surreply.
It's a surreply. I mean, essentially, you put in a surreply.
I don't know that I would call it a surreply. It was more of a correction to an argument that was missed.
And what basis was there for your need for a correction? I couldn't figure that out from the affidavit. It didn't look like there was any new documents, that there was some discovery that your predecessor had suddenly received that changed his position. It just seemed like he'd read the papers again and concluded something different.
I'm not going to disagree with you. I think there was a mistake because the documentation that was referred to in the amended affirmation was on the record. So it's not like there's no new evidence submitted. It was simply a realization that, hey, look.
He just looked at them again and thought there was a different conclusion he could reach.
I think that's what it was. But at the same time, look, they had about a month. They had a month to address and attack the amended affirmation and say, well, it doesn't really matter whether or not there's no documentation, but as to what the emergency was. But on this appeal, since there was no argument to that effect, that remains undisputed, whether there's an issue of fact as to whether there was indeed an emergency. The officer, no, we're responding to an emergency here. Why is there no documentation to that effect? And this was asked for during discovery.
But that came after your predecessor acknowledged there was an emergency in his prior affirmation and in his 9G statement, right? In his summary judgment statement.
I think there was, like I said, I can't there was a mistake. Yes, we agree, okay, at this point, but now we're looking for documents. Wait a second, you know, there's really no proof that there was an emergency. So that's issue number one, but let's assume we're gonna, for the purposes of the argument, it was an emergency. Now you're getting into issues of fact of whether there was reckless conduct. I want to first direct your attention to the Court of Appeals case, Fresel. And in Fresel, the court stated, I quote, "Whether the standard was met here is a fact-specific inquiry, and our analysis focused on the precautionary measures taken by Tampos to avoid causing harm to the general public weighed against his duty to respond to an urgent emergency situation." The Court of Appeals specifically states you're going to focus on the precautionary measures taken, and in this particular case, there is an issue of fact as to whether or not the officers were speeding and flying through that intersection and disregarding other drivers. Now, you would indicate,
Where was
Judge.
that issue of fact created?
I'm sorry?
How did you create that issue of fact?
Because the plaintiff testified that he was going 30 miles an hour through the intersection and got struck on the back of his vehicle and spun around. There's no way the officers are slowing down, not seeing that, getting through the intersection on time and striking my client in the back rear of the vehicle unless they're speeding and going at an unreasonable rate of speed. So there is an issue of fact. Just because they said we slowed down, that's insufficient.
Well, the standard is a reckless disregard. I mean, that's a high standard to really get over, right? I mean, when they're responding to an emergency, even the vehicle and traffic law allows them, they don't even have to turn on their licensed sirens, the police vehicles. I mean, for obvious reasons, right? I mean, they don't want to alert the other folks that they're coming, right? I mean,
I don't disagree with that.
especially if there's an armed robbery going on. So it's a high bar that you gotta get there. It was reckless. I mean, the fact that he's speeding, I mean, we know that. I mean, there's no dispute that he had to cross the double line because there was a car in front of it and he had to maneuver it, responding to a call. Okay, the argument is the man with a gun or individual with a gun. So,
well, the case law states that in a fact-specific analysis and assessing all the factors, in this case, in a residential neighborhood, it's dark out, okay? You're speeding and acting, and whether or not
You want us to infer speeding, there's no direct evidence of that, right?
Sorry?
You want us to infer that there was speeding, there's no direct evidence of that, right?
The evidence of the speed is first of all, the officers don't know, they don't know what speed they were going. So I
they're
think
not
when you
gonna be looking at the speedometer when they respond to an emergency call. I mean, they're just hitting the gas.
Well, I would think that officers with the experience you have operating a police car, you'd be able to at least gauge your speed at the time you were operating the car. But I don't think we need to, you can make the inference reasonably if you strike my client with enough force in the back of the car in the middle of the intersection and spin him around, you're not doing 50 miles an hour, okay? So in some of the first department cases, the officers had actually stopped the intersection before they proceeded through, even though they were in police pursuit. So I also want to point out 1104B says that you have to slow down. Like it obligates the officers to slow down even when you're responding to an emergency. So if you're not slowing down, if you're just speeding and flying through and not paying attention, there's a question of fact as to whether there's reckless indifference here.
Okay, thank you.
All right, thank you.
Very briefly, and following up on the Justice's question, my opposing counsel stated that we did not respond to the affirmation submitted 1 month before the decision was ultimately rendered, and that is for the very simple reason that there is no sir reply in Supreme Court, so we could not have responded. And secondly, with respect to the point that there was no additional document discovery after that affirmation, of course, this is a motion for summary judgment. The note of issue had been filed, document discovery had been completed, in fact, depositions had been completed, and my opposing counsel's client, or predecessor counsel, trial counsel, had certified that discovery was complete. So there was nothing further for the city to produce. And I think the language—
So the record speaks for itself in terms of what we have in front of us. That's it.
That's it. And I think counsel's own language here belies the fallacy of his argument. As counsel said, there's no way I would think that is, in fact, the basis of conjecture and speculation. Thank you, Your Honors.
Thank you very much.